We are participating in the POWESA CBS trade show, and we've yet had another opportunity to interact with the public to do what we are supposed to do. One of the functions of the Judicial Service Commission is to prepare programs for the education of the public and the judicial officers about law and administration of justice. The opportunity has been to bring these services closer to the people. Sometimes it is not easy for people to come from different places and find you in different offices. Sometimes they don't know where they are located. But arrangements like this give us an opportunity to interact with the ordinary Ugandans, the people we are supposed to serve, and share with them matters concerning the law, or they share with us issues concerning the law, and we advise them accordingly. Some of these issues relate to our conduct or to a conduct of a person who has been granted bail. Many of them think that once you get bail, either the case is over, and others think it is an opportunity now to run away, even when they would have good defenses to their cases. But if you are granted bail and you run away, the case has not ended. You will be rearrested. You will be tried again. And there, your chances of getting bail will be minimized because your conduct shows that you cannot be relied upon. 2, sureties. Some people do appear as sureties for an accused person. In most cases, the bond is not in cash. They'll tell you 2 million, not cash. And when a person fails to come back to court, then you must pay that money. So if they give you a bond which is higher, please, you are free to tell court that I will not manage that one, so that you do not run the risk of having to pay through the nose or an amount of money you are not prepared for. Many cases are surrounding land, and more so where there is what we commonly know as kibanja interest. So some of the complaints are the landlord sold, and yet for us we have been there and they are trying to evict us. That is wrong. The landlord is supposed to give the first opportunity to buy to the sitting tenants. But even if he sells to another person, whichever new tenant comes will find this interest of the Chibanja holder on that land. Our advice is a bona fide occupant, a lawful occupant, or what we commonly know as a Chibanja holder. Try to secure your interest, get your interest registered and known, so that whoever buys knowing that his interest is subject to your interest which is already existing. You can do that by 1, technically getting a certificate of occupancy from the landlord, which you register as an encumbrance on the title of the landlord. Some of the other issues are concerning succession, and more so where land is involved. Beneficiaries are claiming for interest from the estate of their grandparents, grandfathers. this is a grandchild, you ask, did your grandfather leave a will? Says, I think so, but I don't know. Okay. Did your father leave a will? No. Who's the administrator of your grandfather? Possibly his children have also passed on, so there is no administrator. Now you're a grandchild. If that land was bequeathed to your father, then it became your father's estate. You can therefore get letters of administration for your father's estate and deal with it as such. If it was not, then you can get letters of administration for an estate of your grandfather, but then you must name all those other beneficiaries who are entitled from the same estate. The challenge I have seen in one of the matters is where someone comes up and he says, we even have a sale agreement, he had sold, but there was no transfer. And then so many years have passed, sometimes 50 years. Now we need to remember that we have a law of limitation. If you have not enforced certain actions, then you cannot enforce them through court as regards land after 12 years. Secondly, you need to remember that in the law of contract, we have what we call privity of contract. Unless you are party to that contract, you cannot enforce it, even if you are a beneficiary of that contract. So the challenge you'll find, even if you had an agreement, who's going to tender it in evidence? How will you rely on it? You are not the one. But of course, I'm cognizant that if you have taken out letters of administration, then you come in to enforce the right of a deceased person, but it will be subject to being still within the limitation period. We have seen issues of land titles, especially land which has been taken by government to construct roads, and the titles were surrendered to UNRA to be able to survey off part of the land that was taken up by road development, and those land titles have not been returned to their owners. The challenge is that sometimes it is not deliberate that they are not returning your title, but possibly they have not finished the surveying. But the inordinate delay, the long delay, cannot sufficiently be explained. So if you do not get sufficient explanation from UNRA, then you can petition court by way of the prerogative rights for them to do what they must do and return your title. If you discover that the survey was done, and you can do that one through a search, and you see how the land still stands, then you can sue them for an order that this title be returned to you. We are seeing a lot of issues concerning domestic violence in homes. Yeah, it is good when you make your vows to keep them, but when the misconduct or the conduct of a partner within a home threatens your life, your physical well-being, your health, where there is cruelty in one's conduct, there are some legal avenues of saving yourself. We have seen where domestic violence degenerates into even loss of life or grievous bodily harm or permanent injuries being inflicted or suffered by the victims. There are legal remedies. One is where the grounds exist, you can petition court for divorce. It is better to dissolve a marriage, live separate lives, instead of putting yourself at risk. But that should be the last resort. The first attempt would be separation. We have judicial separation. You can petition court for separation. If you have failed to agree, then you can make a separation agreement to spell out the terms under which that separation will be conducted. For example, you can agree to stay apart, but you allow visits for the children to see the other party, the other partner, for the children to be catered for. For one of the parties, in most cases the husband, to continue caring for the family while they stay apart. You can make an arrangement so that you minimize the risk of causing each other more harm. Matters like desertion, deserting a person for very many years, and you think somebody will just stay there and wait for you when you return as if nothing happened. When you leave your wife or your husband for 2 years without agreement of your absence, then that is a ground for separation. It is actually a ground also for divorce in case there is a feeling that there is an irretrievable breakdown of that marriage. So once a matter has gone to court and court has made orders, those orders have to be complied with in the terms stipulated by the court. If you find that there is a variance, they have not been implemented as required, the only remedy is to go back to that court which issued it and make your complaint by way of review. The court will be able to look at that matter and address it appropriately. Another issue which comes from that is also where you see that a deceased person might have left only a home as an asset belonging to his estate. But this home is where some of the dependents were living. Now that property is not available for distribution. That property is supposed to remain to be used by the people who were living there with the deceased at that time. So this idea of sell and we share now the changes in our succession law do not permit distribution of a family home. So we need to be mindful of that. Many times the people will go into, they really need the advice of counsel, an advocate to advise them or to represent them. In that case, we have several organizations that give legal aid. One of them is Uganda Law Society, has a legal aid project. There is one which is run at the Law Development Center. And then we also have just centers in Uganda and other non-governmental organizations. If you cannot find help, you can always contact the Judicial Service Commission. We will not represent you, but we will advise you on what to do. We will possibly advise you which people you can meet and get the appropriate advice that you might require. Judicial Service Commission, one of its mandate is to advise the public about law and administration of justice, and this we do free of charge. We can find the Judicial Service Commission at Kingdom Kampala, 8th floor. You could also call toll-free number 0800-100-221 during working days and working hours, and you'll get help. You could also try to reach the Commission at www.jsc.go.ug, or you can email at info@jsc.go.ug. You'll be able to get help. If you are in Masaka, we have our office near that block which houses the probation office. If you're in Mbarara, at the district headquarters, or if you're in Moroto at Jelo's house, we have regional offices. There will be someone to serve you. Thank you very much.